can eat and kind of have a conversation. We have a nice small group that I think lends itself to that. We'll get started. So, first of all, very grateful for our panelists who agreed to join us today. So, thank you very much. I'll do a brief introduction. And then each of our guests will speak a little bit to their experience with legal research and practice, or their thoughts on legal research. We've given them some discussion prompts to guide them along, but I think any thoughts they can give us on the matter would be very helpful. And then after they each speak for a bit, then we'll open up to questions. So please be thinking about your questions, and we'll get to those in the end. All right. So our guests. First, we're very lucky that Justice Larry Starcher is a familiar face to us here in the law school. Justice Starcher is the former Chief Justice of the West Virginia Supreme Court of Appeals, is currently a lecturer in law, and recently teaching trial advocacy. He's also an alum of West Virginia University, both as an undergraduate and law. Thank you, Justice Starcher, for being with us today. Kevin Gillen is also a graduate of the College of Law in 2011. Worked for 5 years with Jackson Kelly in the administrative practice group, 2 years with Kay, Casto, and Cheney in insurance defense litigation, and currently works as a judicial clerk for Judge Christopher McCarthy in the 15th Circuit. And Krista Ford is the Director of Library and Research Services at Steptoe & Johnson. Joined the firm in 2013 with 20 years of experience in business and legal research. She's responsible for all aspects of the administration of the firm library, and includes supporting the research needs of the firm's practice groups, maintaining the print resources and contract negotiations, and establishing the firm's knowledge management platform. So thank you very much for our panelists. They have a lot of experience and advice for us, I'm sure. So, Krista, if you wouldn't mind starting off.
No, not at all.
Sharing your thoughts generally, give everyone a chance to speak, and then we'll talk about our questions.
Yeah, thanks everyone for coming today. I hear there's a ball this afternoon, and we're competing against it, but thanks for joining us. My name is Krista Ford. I am Director of Library Services at Steptoe. So we generally get several summers that come to our firm from WVU, which is wonderful, and I hope to get to see some of you this summer. Typically, I start off the summer with our interns doing a library research and legal research. I guess we're calling it a, what do we call it? It's research speed dating. And what that program is we spend some time with each one of our law students going over all of the different resources we have in 10 minutes or less. So that sounds like throwing you guys into the fire, but it's purposeful. A lot of our tools are relatively intuitive. Many of you have spent the last 2 years getting to know Westlaw and Lexis and all these other research tools so well that you don't need hours of instruction on them. So what we do is we spend a little bit of time on each one of these tools, and then we send you off on a research project. So the research project usually takes about an hour and a half, and it's designed so that you get to use all the tools that we go over in this sort of 10-minute overview. That way you get not just in-depth knowledge from using it in university, knowledge of hearing about the tools and what we're using in practice, but then you have that sort of tangible getting to know it by being in it. Because many of our tools are relatively intuitive and they connect with one another. We do have a few tools. So we have these prompts. I'm not going to go through it, but if you have any specific questions. The tools that we use in my firm are Westlaw. We're a sole provider now. We used to have both Westlaw and Lexis. Now we just have Westlaw because it integrates nicely with some of the other tools that we have that you may not be using here in the law school, like Practical Law. Practical Law is the tool that we've implemented in our firm to really help, especially newer associates, summer interns, with legal research because it gives you a lot of paradigm documents. So if you're drafting a contract, or if you want to know the language that people use when they're writing a mineral title, which is my firm is heavy in energy, mostly. That's where most of our business comes from, though obviously we have other practice areas. If someone's joining our firm and they might not have a lot of experience doing energy law because it's very specific, we have tools in place like practical law that can help get you up to speed in a quick way so that you can speak articulately to other attorneys, to the clients that you may come in contact with. And it's really a valuable tool we like to have, especially our summers and our newer associates, get in there, use it, pull it, see what we have. Now, some of the restrictions that we have on legal research that you're going to find out during your summer internships is that some of the contracts we have charge back to the client. They charge for downloading documents and things like that. In law school, I'm assuming that you have not run into this barrier yet. That's going to be a big difference when you come to a firm, you're practicing in a firm, is that when you're conducting research, we will be charging back to the client or charging the firm overhead for a lot of the research that's conducted. Only some of our programs do that, so that would be a Westlaw, which here in-house, I know you guys get to use open access for free. Pacer charges us by the document as well. Circuit Express, which is specific to West Virginia, so that would be circuit court opinions that lie outside of Pacer. And we have one or two tools. The rest of our contracts are open access. So something like a practical law, we actually pay an annual fee so that you can get in there and search ad infinitum. There is no restriction. You don't have to worry about it being charged back. But part of the program that we implement in trying to train you on doing legal research is you want to be smart and efficient when you're doing research in tools that charge back, right? So, there could be a huge difference between knowing what you're looking for or doing a search where you get 10 documents and doing a search where you get 150 documents. The charge is obviously much more significant. We have a very nice arrangement with Westlaw currently as far as our cost per document in that sort of tool, but we still like to make sure that, when our folks come in, that they're utilizing the tools in most efficiently possible. So some of the projects that we give our centers when they come in are some of the things that I ask them to work on in sort of this research debrief that we spend together during their orientation process. And those, again, because our firm specializes in energy, are usually related to intestate law or mineral title or things that you would think would be easy. But when you're talking about old regulations, old code, when you're sort of finding your way down the rabbit hole, who owns what, how do I even get in touch with these people once I figure out who owns this property, who owns these mineral rights. We do a lot of those kinds of projects because they're not cut and dry. It's not easy, it's not as superficial as, just pull a section of code for me. Those things are easy, they're intuitive, they're easy to figure out on your own. That's not what we want to train you to do. We want to train you to do the difficult things. Some of the other projects that we give our interns would include being able to compare law. So we have several different states that we have offices in, so we have multiple jurisdictions. We have Colorado, we have Texas, we have Kentucky, we have Ohio, we have West Virginia, Pennsylvania, and we have, perhaps you're working with a client that has offices in all these different jurisdictions, or maybe there are offices in 50 different states, all 50 states. Sometimes we have rules of law that we have to research because there's a nuance state to state. There's something that's different in Kentucky, there's Ohio, and so we do a lot of those comparatives as well. We have our summers sort of look into those different nuances and building charts and being able to understand that, you might understand West Virginia law very well, but if you were to practice in Ohio or Kentucky or, be a full service asset to a client, you have to understand what the difference is between not just the state that you're working in, but every other state that impacts them. So, we have a lot of interesting projects, I think. We do support our summer interns throughout the summer, so I'm usually there all summer long, with you guys. The truth of the matter is that our attorneys love to hold on to those really hard things when our summers come on board, because we want to keep them engaged. Sorry, did I let the cat out of the bag? Not really, but they'll hold on to something that they know is a little more challenging so that you guys stay engaged. And part of, I think one of our prompts was, what are the characteristics that we want to see in our summer interns, and some of the things that will help you excel in legal research, and tenacity in asking questions. It's sometimes, like I said, it seems like there's nothing out there, but it's really just down a rabbit hole. You have to really look. So the key to that is ask questions. Make sure that you take advantage of all of the resources that you have available to you. You have 3 months with us. And I can tell you right now that, in theory, practice and theory are the same, but in practice they're different. So here, you're learning all about theoretical law, but in practice, it's going to be a very different experience for you. Okay, things aren't always cut and dry, and sometimes kind of, like I said, go down the rabbit hole. So make sure that you take, this is a great opportunity to learn what the real business of law is, and doing it from people who are really experienced, that are willing to help you, that are engaged, and want to see you succeed. So make sure you take advantage of those opportunities, because you will get the hard projects, I promise. Okay, that's all I have.
Thank you very much.
No. I'm a checklist guy, so I'm going to follow the prompts. One thing I would build off of that when you're talking about efficiency, and that was one of the things that I thought about a lot when I looked at these prompts and a couple of questions, and there's also finding a balance between that efficiency and that tenacity, is knowing where to draw the line, especially like you said, when things are getting charged back, and knowing when to go to somebody and say, I'm down a rabbit hole, and there's no end to it, because I'm not finding what I'm going to find. And it may be that there is an answer, and it may be that there's not, or it may be that there's a shallower rabbit hole to go down, so to speak, that you hadn't thought of. But I agree with that 100%. But a lot of, especially at the bigger firms, you get a little bit more leeway as a summer associate in the efficiency department. But once you become an associate, and your hours really matter, and they matter not only to partners but to the clients. Then that's where you really need to draw that line in research efficiency and learning how to be efficient. I'll touch back on that, because that was one of the things I wish I'd learned a lot earlier in law school, was how to research efficiently. I was more of a Google type researcher, of just going to Westlaw and typing in a sentence, like a Google question, and not Boolean searching and things of that nature. And I wish I'd learned that a lot, because it doesn't matter here, right? You're up in the library, the only asset you're wasting is your own time. So that's really what I wish I would have learned earlier. But as far as types of research tasks that I was asked to perform, one thing I guess that wasn't in my bio that I didn't provide. So I did a summer, my first summer I did with Judge Keeley, an internship over in the Northern District, and then my second summer I was a summer associate at Jackson Kelly. And some of the things that I was asked to do as a summer associate were a lot. What Chris said was, I was given the types of research projects. I was really given, I think, 4 types of things to do. I was given projects that you'd see in law school, a research project where they want a legal memorandum that they don't, that they don't know the answer to the question. Can you find, are affidavits admissible as hearsay evidence in administrative, tribunals or whatever? And all they want is a quick answer and a research memo. And I was given those type of questions. They don't, the partner who's giving it to you doesn't know the answer to it. It may not be that simple, it may be a simple question, but they want the answer in the form of a legal memorandum. I was given projects, other types of projects that were, I want research to back up this argument. This is the argument we're making. I want cases, I want statutes. There's nothing in West Virginia, so I want cases outside of our jurisdiction. I want statutes that have been interpreted outside of our jurisdiction that back up this argument specifically, and I want a counter argument to their side. So it was, less a legal memorandum than working on a portion of a brief or an argument. The third type of, maybe it was only 3 that I was thinking of. Anyway, those were the other things we were done were that I was given were the long-term projects, like updating a litigation handbook, updating the 50 state surveys or 25 state surveys that the firm kept as a research tool. We were the ones that did that, and part of that was to build our research and that type of knowledge and to help us to learn the tools. But another thing they're looking at is how do you, as a summer associate and as an associate, how do you balance long-term projects that you work on all summer with the short-term projects that you're given that are, I need this legal memorandum, I need it by Tuesday. You can't just drop everything. You have to learn to balance your time. So there's that aspect of it as well. Those were kind of the types of things that I was given as a summer associate and as an intern. I'd say the way that type of research and things differed from what we did in law school was you just had to be more efficient. You just had to be more efficient at it, and you had to do, in law school you're given maybe one obviously you have other things, but at least when we were in legal research and writing, we had one memo at a time, and we could spend all of our time on that, and there was no harm in finding 10 cases that supported one point of law or one argument. It was, when you're a law student, well, if I can, 10 cases is better than one case. Well, in practice, you don't need 10 cases, and as a law clerk, I can tell you, I'm looking at the first one. I don't care what the other 9 are, I'm gonna look up that first one because that's what I got time to do, and if that supports your point of law. I mean, if you can add 2 or 3 that add a specific point with a case note that's, that really is powerful, then provide it. But, being efficient means finding one case that supports your point of law and doing it. And I'd say that's really where my legal research and practice differed from law school, is that you just had to work more efficiently. I think the difference between good legal research and research that's good enough is, I was thinking on this one a little bit, and I think a lot of, in my day-to-day experience, in the briefs and the research that supports the briefs that I see on a day-to-day thing, they're good, they're well written, they're well cited, but what they lack is a lot of times they're perfunctory. They're persuasive in that they say, this is, the court's just fine for my client because of this case. Well, and they throw in some clearlies and, undoubtedly's, the facts support this, but they don't explain to the court why. Why should the court go down? Because if it's before the court, like you were saying, a lot of these questions, if it were clear cut, there's not going to be 15-page briefs on each side or 25-page briefs on each side of the argument. If it was clearly a case for one side or the other, or undoubtedly a case of one side or the other, you're not going to be where you're at. So a lot of times, and I don't know if I'm really saying, what the judge wants to hang his hat on is when I bring it to him, he wants me to come and say, to write a memo that says, this side's argument is clearly more persuasive and we should hold on this side, even though we could go the other way, because the statute that these people cited was more similar to the West Virginia statute, or the facts of the case were more similar. He wants something an argument that has some sort of basis that we can hang our hat on, so we're not going to get reversed. And if you can find that and keep that in mind when you're writing an argument, it's one thing to be persuasive, but if you can give just a little bit more analysis to explain to the court why should they find for you, because the statute that this court is in, you should follow this case law from Colorado because their statute is word for word like the West Virginia statute, whereas on the other side they rely on an Arizona case where the statute that they're interpreting to find their side isn't the same. It's just go that extra step to explain why, rather than just citing a Colorado case and say, well, they found your way here. But why does that mean anything to me? And I think that's what separates good from good enough, really. I think I touched on how my legal research has changed over time. Rather than spending 5 or 6 hours up in the law school clicking away on the computer, now you get 35 minutes. It's, I have learned to become more efficient. I've learned to use the tools that are available more efficiently, and I've learned to do a Boolean search. Never thought that'd be a milestone in my life, but it was.
Westlaw does it for you now. Westlaw does it for you.
But yeah, Westlaw does it.
It builds it for you.
Right, and it's and I've also learned to narrow down. I've also learned to use that slide on the narrow down the cases rather than just scrolling through 250 cases. I use my folders on Westlaw. I have tons of folders on Westlaw. That's how I organize my research. If it's something that I know I'm going to come back to, I print it out and I keep folders, old-fashioned manila folders at my desk.
Can I make
Yeah.
note of that? On foldering in Westlaw, if you put something in a folder that you know you're going to use again, you can actually access it digitally within the folder without getting charged again for 365 days. Sorry.
Oh, cool.
There.
I didn't know that. Let's see, managing costs and reason. Now that my access to Westlaw is a lot like your access to Westlaw now as a judicial clerk. The only thing, so I don't do much to manage the costs. Again, that goes back, Chris is the one to talk about that. Managing the costs, not only in what you access and get charged back to, but the time that you spend in research. Is how you manage costs. I'll tell you from this isn't from my own experience, but the one thing that was always pounded into my head at a firm was never click on something that's out of your subscription. Just don't, because when the firm gets the bill or whoever gets the bill, their head will explode. Apparently, that's what I've been told. I never clicked on it. So it's true. And Kirsten's head is still intact, so apparently they listen over there. Let's see. I only really use Westlaw. We had access to Westlaw and Lexis while we were in law school, and Westlaw appealed to me more. I don't know, or maybe I forgot my Lexis password and just always went to Westlaw. For some reason, I've always used Westlaw. I fought and fought to not use Westlaw Next, but now Westlaw Next is all I have. That's not to say that I don't use other online databases. The West Virginia Supreme Court puts all their opinions online. A lot of, when I practiced in the administrative group at Jackson Kelly, I practiced before the Department of Labor Office of Administrative Law Judges. All of their opinions are online. So again, being able to go out and get those for free. Also, the research tools that are available at your firm, the internal research that you have, the 50-state surveys, the handbooks, the practice group specific research that you have is all available to use too. Westlaw is great, y'all are totally familiar with Westlaw, but your goal will be to learn to work efficiently within the tools that you have and when you can't find Westlaw. Or Westlaw may not be the best resource to go to find what you're looking for. Let's see. Resources I touched on. What I wish I would have done in law school to better prepare. I wish I had, learned to research a little bit more efficiently. But I think you're armed with the tools that you need to have. And again, I think the big thing in research is keeping in mind research is so unique to the person and to the project and to the attorney that you're doing it for. What you may do on one project may not be what you do on another, the way you go about your research. Again, you may have an attorney that says, I need an answer to this. Don't spend more than an hour. I mean, I know there's an answer. I just want that answer. You don't have to come out with a 10-page legal memorandum. It might be good enough to say, this is the statute that applies, or here's the case that you need. Again, there's things that require deeper research, and it's really just always keeping in mind why you're doing the research, who you're doing it for, and then also keeping in mind sometimes the best solution isn't. I had a 12B motion to dismiss that I researched thoroughly, and it was my opus. It was a beautiful, beautiful 12B6 motion that was thoroughly researched. It was a legal masterpiece. It was a lack of jurisdiction. I did an international shoe analysis. I had 2 case summaries. I distinguished the cases they were relying on as to why this case should be dismissed for a lack of jurisdiction. Gave it to my senior partner. He filed it, went into court and argued it before the judge, and didn't even touch on it. Didn't even give a legal argument. He said, Judge, if we take this case, if you keep this case in your jurisdiction, this case revolves around a house that's in Connecticut. Because we're going to have to get the jury, the attorneys, and you on a bus and go up to Connecticut and look at this house before we do anything. And just said, I'm not doing that. Dismissed. I'd like to think it was my brilliant legal argument analysis, but I think it was that the judge didn't want to get on a bus to Connecticut. But when the written opinion did come out dismissing the case, it used all my research, so it was worth it. So again, keeping in mind why, and sometimes you'll have brilliant legal arguments that you've researched and found, but they won't be worth a lick in court. So that's my 2 cents.
That's for the bite. I'm going to go to someplace a little bit different. One of the main reasons is I don't know a damn thing about the Westlaw research. Ask Nick. And I'm assuming that you ladies that are here are anticipating trying to get a summer job in a good firm and learn how to do these skills, and I think that's very, very important because, and I expect that every one of you are hopefully saying, and I'll be able to latch onto a little niche where I'll be employed when I graduate, but all of you won't be. Expect that because it happens every year. But it's good. It's a good thing to do what we're doing here. I thought I would put an umbrella on it and just talk about this is not the only place that you can have summer employment, because the top of the little list says ace your summer job, and you have better ones than I did, I hope. My first one was, my first summer job was being a union laborer building a power plant, wheeling concrete in a wheelbarrow, and worked 123.5-hour day one time. I'll stop them. My second one was as a university hospital janitor. That wasn't very classy either. So you keep on the ones you're trying to get on. Eventually, I want to go to map where I've worked, but I wanted to say a couple weeks ago, I was in Ohio, and I was on a panel that was a training program for legal aid lawyers, some rookies and some pretty old-fashioned ones from 4 states, Michigan, Indiana, Ohio, and West Virginia. And we were addressing at that time oral speaking. How do you speak? How do you address a judge? How do you argue before a judge as compared to a jury? Totally different. It's totally different. We did that, and at the tail end, when I was preparing for that, I couldn't help myself because I was talking about understanding. The key thing with the judge is, or a panel of judges, is make sure they understand it. Don't worry about that little sensational, emotional thing you like to throw in before a jury because they're going to bite on it. They don't want that stuff. They want to understand. And the other thing, the key, and I can't keep from telling you this, is when they ask you a question, you've got to stop whatever you were saying, put a period there somehow, and somehow remember that's where the period was, and come back and pick it up. But and answer their question, because when they're up here at the law school, if you notice the 3 judges from the 4th Circuit, all of them said the thing I like least, that peeves me, is me asking a question and then them sliding it aside or going around a little bit and not answering it. And so, and there's always this answer that is, I don't think I know the answer to that, Your Honor. And the judge will like you a lot more than if you're trying to avoid it. But I did slip something in the back end here where it said written communication, brief comment, because I couldn't keep myself from doing it. And I wanted to talk about rules and accepting that people have written the proper. We're going to accept his wonderful brief and we'll use it. And I accept that it is that good. Actually what I wanted to say is, when you're doing that kind of a project, really a key thing for judges, at least judges like me, is its general appearance and readability. When you hold it up, does it look like, this is something, I never typed before 2009, because I had the same secretary for 40 years. When I came here, so I learned to type. I typed this morning. It looks like it's in order, it's not all garbled around. You got nice margins, proper. Those two things really get first look. But the biggest thing is your product won't get looked at if it's not well written and well spaced and looks attractive on the page, because judges like for their pleadings to look that way. Sloppy work really lowers your degree of credibility with the court or the judge or whomever you're addressing. I can assure you that. And if he had, the same words had been done in a sloppy fashion, it would not have been worth, it would have been worth less than it was, apparently. I know that feeling, and I've had to tell somebody else, I know you wrote that, but listen, all we gotta do is hop over here. And I actually got a lawyer aggravated at me a couple of weeks. I still do senior status judging in Brown State in circuit court for fun. But I told this young lady, I just stopped her because I was going to rule the way she wanted. I knew what she wanted. I can read. And we had to cut her off, and she thought it was a big treatment over at me. On the final point, this was mentioned also, and this is very important too, I think. If you think that judges want to read 25, 35-page briefs, you're whistling Dixie, because they're not going to. They like 10, 12, 15 at a max if you can. And I will venture to say that in my years that I've been a judge, which is since 1977, and not many of you remember that year, Mark might. What was I going to say? See, that proves I'm getting old. You don't want to write that many long briefs. If you can avoid it. Now, sometimes you can't. I mean, there's complicated cases that really drive everybody nuts, from your level up to our level. Let me just tell you in a very quick fashion the places that I've worked. I answered Mark's little test he gave me. All answers, Mark. And I tried to make them neat. I started out as a assistant to a vice president of university. And I got out of that fairly fast because one of my jobs in that job was to write grants. And I wrote a grant for a legal aid program for this part of the state, a 6-county legal aid program, in conjunction with the law school. David Hampton was at the law school. And that was really a turning point in my life, because I really wanted to get in the courtroom. I wanted to have some fun. And so we got the legal aid program going, and it was there. But all the time I was there, starting in 1969, I had 2 or more law students working in the office. Now, I'm going to talk about is there are other things you're going to get to do, thank God, than working and pour out these memorandums of law that we rely on as judges. We do rely on them. They're absolutely necessary because, you know, dummies like me don't know how to get out of the rabbit hole. I just keep stepping in, and that's what I do. And she talked about titles to real estate, mineral interest in particular. They are a nightmare, aren't they? I've had cases. I wrote a summary judgment, I think it was about, broke my rule. I think it was 35 pages. But did I do that all by myself? No. You know what? I had a student from W&L Law School that summer, And I worked on it, he worked on it, I gave him the materials, got him started, told him what we tried to do, and they did. I gave him a good example of a pre-trial, or excuse me, summary judgment order, or in another case we've done it, and I said, this is kind of the style I use. This is the style I use it, so I used it, you probably couldn't get me to change it if you tried. And it's pretty good, I think. And I told him to keep on that pattern, and he had to dig through some of the darndest stuff you've ever seen, and then you come up with, well, it could be either this or either that. I'm not sure which one it might be, and you don't flip a coin. I mean, it's one way, but he got to do that, but he got to do that with me as a trial judge. Now I was working as a trial judge. I was a trial judge from 77 till 97, and then I was a Supreme Court justice for 12 years. Now there, it's not hard at all. The way we did that is our whole staff, we would bring all the cases in that were getting ripe to be heard, and we would talk about, are these things important, things that we want to do? Is this one we would want to really invest in and let everybody, maybe it's not going to be my case. We know that, but it wasn't assigned to me. It's what we're going to do. And we will say, well, we want to put our nose into this one because it has this issue of its liability on property. Damages when people get hurt on their property is something that I've nursed and got to change to a little better, but we've never got clear quite where we'd like to. But we get something like that, we want to put our finger on it. But then we decide what cases we have. We know what ones we have. We pair them out to who's going to be, which clerk's going to work on them with me. And once we discuss them a little bit, then we disperse, and then we get one-on-one. And I'll go through with each one of them. And the way we did it is that first we talked about it. We read it and enough about it to talk about it to know. We get a judicial brief, a little mini brief on every case. And then we decide what direction we might want to go, assuming that what we know now is right. Sometimes it's not, but assume it is. And then we make a little outline. We made a little outline, and then we put the clerk to work and come back when we can. And I had some really fine clerks. Tom, we'll just call him Tom. He was an excellent wordsmith. He just had a way with words that flowed, and I liked him. But he didn't know a damn thing about transitions. I'd say, read it, I said, Tom, there's a rap going down here. This goes up here, you know. And he said, well, you connect it. So I figure out the best way to connect them. Richard was an aerospace engineer as an undergraduate, and you thought he was writing something for a piece of research on whether he wanted to fly to the moon again. Well, not really that much, but it was it sounded like a mathematician wrote it. And it had nothing in there to warm your heart. I mean, it was just a cold language. But the analyzing, the analytical stuff was really there. It was really great. And he'd say, well, you just fix it however you want to. I won't make him mad. Well, whether it would make him mad with it. Helen, who graduated from the University of Pitt, which Pittsburgh, I guess we ought to understand this. She was on some kind of was the editor of a something review. It was a sub, not the law review, but a sub something rather. Hers work, when I got at it, it looked like blood was running off of it from my red pen. And I said, Helen, that could not have happened that way. And she was trying to tell me how this processed through the system. And I said, Helen, that's not possible. That's not possible. Bring me the whole file. Here she comes down with 2 boxes, banker's boxes with stuff, and we start going through it. But it was really hard for me to figure out, in all fairness to her. But it tickled me because her father's a lawyer and my good friend, and I showed him that paper. It was all became a joke. It didn't. Peter, my best writer, though, Peter had a real bad fault with me. And that was Peter never said anything in 15 pages that he could possibly grow into 40 or 45 or 50. And I said, my God, Peter. And I X out a whole paragraph. No, we need that. That's good, that's good. And I said, it is good. I like it. But we're not going to be producing opinions that size. And I try to get them to buy into the position that we should not, unless it's the exceptional case, we should try to keep our opinions 30 pages or less, our full opinions. We really should try hard, and some people followed, some people didn't, because we made a decision to do that, and no more than 5 or 6 on the ones that we were not established another syllabus point. By the way, the syllabus points that we use here in West Virginia, I don't know of any other state that does, but there may be one. And I think what we do is very good, because that becomes the stated law, like a statute, for a given time until it's either modified or tossed out. And I think it's a wonderful system, and when I was out there, I knew that these states didn't use it, but part of what I said was a syllabus point, and it's so important to you, it's something better than just a cite and some numbers, because it tells you something. Let me see, I don't know if there's anything else I wanted to say. I could read my answers to the quiz he gave me, but you wouldn't find it any more interesting than I did. I think, oh yeah. Research and writing. I did make a note down here about it. I forgot. I'm going to comment this one too. Much better now. It is. You all are really, you and the ones right before you every year, they're much better because we have people like her. Because the big operations they couldn't manage without you, could they? Be honest. No, they couldn't.
Can you tell my boss that?
He almost loves you, I guarantee you. Two papers. No, and letters. This is one of my really screaming things that I just really get angry when people can't do it. A business letter. I've taught here, Triad, and I taught, what's it called? What do we call it? Pretrial litigation, trying to do something. Pretrial litigation. And I discovered, and I think I'm right when I give these estimates, that only about 50%, and when I say you, I don't mean just you, I'm assuming you're the smarter ones or you wouldn't try to hook up me taking a trip down the way that the people that have bad grades just aren't going to get to go there. That's what it amounts to. I forgot what I was saying. What was I saying?
Business letters.
Oh, business letters. Half of the students here can't write a decent-looking business letter, and it really angers me. And I went to pre-trial lit class one evening, and I had some stuff, and I pulled a waste can up right next to my desk where I was sitting, and I said, I took 4 of them and letters, and I looked at them, and I just had red ink all over them. Corrections to this, tried to draw lines where the margin should be, and I said, I don't want to do that one, it won't be funny. I don't want to, that's my research right there. And I would look at this and I'd say, if this were a letter, a cover letter, or a resume, it's right there's what would happen. Resume with it. And I did 4 of them, and I built into my class. He had to write 6 different business letters at certain times. And some of them you'd say, well, one of them was really to teach you the importance of it. After you did your interview with your client and you did your you were getting ready to go to work on your case, you either accepted them as a client, and they assumed you did at that time, and you said you were looking into it. So I said, now you've got to write them a letter and tell them you can't represent them. But you really got to. But you got to write a letter, and I'd give them some clues as to reasons they could give, and then write that letter. And so I started grading them, and I gave heavy emphasis on grading on them because I just think it's embarrassing to say we're sending students out here who can't write a business letter properly. I know the parts of them. It's just like arms, legs, whatever. They have parts. They belong in places where they go. Contracts, pleadings, all those types of things, they need to look good on the paper because you'll be judged immediately about if it's a physical, sloppy thing. Don't do it. On written legal work, simple as ABC, I say accuracy, brief, and clarity. Then just toss in style, that's what I was talking about, how pretty it looks, and neatness. And if you spill ink on it, start over. And good writing is rewriting. I don't have anything else to say.
Thank you very much to our panel for sharing their some experience and expectations for taking some of these skills into the real world. If they'll, I know we're at 1 o'clock, but if they'll close for a couple minutes, anyone have any questions?
I was kind of wondering about secondary sources, and that's something we kind of like touch on, I guess, in legal research. But when do you find yourself like leaning on them or using them? Or...
I find myself leaning on
Why
secondary.
don't you speak a little louder?
Oh, second.
Learn to do that, lawyers to me. There's boys out there, talk to the back of the room, like Nick.
Okay, well, I'm Natalie, and I was wondering just about secondary sources. We kind of touched on them in our legal research class last semester, but not very thoroughly. And so in practice, just practically, I was wondering how often, which ones are great that attorneys use them.
I find myself leaning on secondary sources when I have like no idea where to go as a place to begin, or if I just can't find any, if I've done, not an exhaustive research, but if I start off and I just don't find anything in West Virginia that's on point, I go to secondary sources. Just this week I did research on what we call hybrid representation. We have a pro se plaintiff, we have a pro se, well, he's not pro se, that's the problem. He's represented by counsel, he's a prisoner on a habeas proceeding, and he wants to, at the same time he's represented by counsel, he wants to file filings by himself to the court. He wants to be able to file motions on his own too. And he actually filed a writ of mandamus and prohibition against the judge down in the Supreme Court to allow him to do that. So I had to write a response, and I said, the judge said, do you know where to start on this? I said, I don't know. This is unheard of. And it doesn't seem like a very good idea. So, in that case, the first place, I did a quick search of hybrid representation in West Virginia. It came up nothing along these lines. I couldn't find anything in West Virginia. So I went to ALR. And sure enough, it popped up, and it talks about all the cases that this has been addressed in. It ends up 26 states have said,
You tell young
this
Judge,
is not a good idea.
you tell young Judge McCarthy the thing to do is just take that letter that comes to him, because I've had hundreds of them, and send it with a cover letter of his own to his lawyer and tell him to take care of that.
Yeah, that's what we did. And then when his lawyer gave it to him, he didn't like that, and he filed a writ in the Supreme Court. And his lawyer, that's the one I sent to the lawyer. Said, hey, it's got a writ. But yeah, that's when I go to secondary sources, is when I can't find anything.
When there's no precedent, it's
Yeah.
typically when we, advise people start with secondary because it will at least inform you on the topic so that you can write an articulate explanation to the court as to why you should find in one way or another.
Any other questions for the panel?
I have another one. It might be more directed at the professors in the room, but there's a lot of certifications that you can get in research through like Lexis and Wes. I was wondering if there's one that you recommend, maybe like a best kind of, gives you like an overview of how to use all that.
Well, I think, in my opinion, and I'll let the other two share, I think because they come from the vendors, they're all going to be pretty similar, but they're all going to be exclusively for that platform. So if you go to Westlaw's Prep to Practice, you're going to get Westlaw's point of view from the vendor. So I think in those cases, you have to take that with a grain of salt. You're definitely getting the vendor's point of view on their product.
Okay.
And their resources. So I think to just go to one, I think you'd be missing out a little on the others, just because of that point, say the biased point of view there. That's a Westlaw rep giving you training on Westlaw. So I think it'd be difficult to just go to one and consider and kind of check that box. If Westlaw and Lexis were both offering them, I'd recommend going to both and keeping an eye out for, knowing that you've got a vendor rep instruct you on their platform. So keeping that kind of in the back of your head while you listen. They have great advice and great instruction for the most part for you, and keep in mind that they're representing their product. Yeah.
I couldn't agree more with Professor Miller. I also think just getting certified on as many as possible and then like listing that on your CV is a great way just to market yourself, right? Just to show that you,
I agree.
yeah, know the ins and outs of all of them.
When I was at Dickinson, legal research was a year-long course, and we required that our students be certified in both Lexis and Westlaw. And that was part of the reason, was that then when they apply, the firm says, hey, we use Lexis, this person has been certified in Lexis, we don't have to start from square one training. They're not going to come here and tell us they spent the whole year using just Westlaw and they don't know our system. They knew both, and so we can send them out that way.
And if you have the time, why not do Bloomberg or Hein or whatever else? If it shows that you're certified on a tool that folks aren't even aware of, makes you look cutting edge, right?
Do you have any further opinions on that?
No, I think, getting into these tools, learning how to be efficient is truly the key here. I mean, there's a lot of stories that, we can tell you guys, but that is really the most important thing, is to make sure you're thorough but efficient. And I did want to speak to your margins and your presentation of documents. We actually have a tool in my firm, Drafting Assistant, that by jurisdiction will actually outline the margins on the outside and all of the spacing that's required by the court. It's called Drafting Assistant. If you're a summer at a firm, then ask about it, because it really does help
Yes.
put you in the right place. I mean, obviously, we have a lot of tools in my firm that we've implemented for these process efficiencies, but knowing that they're there is half the battle, right? So you have to make sure that you know the tools that are available to you to do your best job.
There's also another thing you need to know, not rhymes with tools, it's rules. There are rules. There are rules as to the size of the prints you can use for a footnote and whatever. There are rules on the size of the margins. There are rules on so many things. Trial court rules. If you're doing something for this young man's now working as a trial judge, as a trial judge's clerk, you really need to know those rules.
And I was going to add in there before Judge Archer said rules is that goes back to your research too. You need to know your rules. There's page limits.
Yeah.
I mean, if you have 5 issues to deal with and you got a 20-page page limit, know that your research is going to, you can always make a motion to exceed the page limit for good cause, but keep that in mind when you're doing your research and what you're doing it for. Again, I don't want to tell too many stories, but we just yesterday, I wrote an order redirecting a council up in Pittsburgh to resubmit something in compliance with Trial Rule 22.01. They submitted a 33-page motion to dismiss and a 27-page their motion to dismiss.
On selling paper.
Right. Their motion to dismiss exceeded the page length of their brief and memorandum, brief and support.
I don't know how many pages the Supreme Court's limited to now, but for the first brief, one time, I think when I started, it was 60 pages, and I know we cut it down some. I don't know what it is right now. But there's an anecdote to that. I've read some early things about our court getting started here in 1863. One of the very first rules they had to make was to lower the opening statements in an argument of a case they accepted from 6 hours to 4 hours. And I went, God. Well, I only had 2 or 3 cases, right? So they had to earn the money. They had to earn their keep. But rules, there are lots of rules out there that if you're going to be in the business, the backup, if you aspire to do this and do it as a lifetime, as a job, that's wonderful if you do. It's not a bad job, is it?
I like it.
I know you do. It's a good job, and if you work for a good firm, it's a good place to be. But you just want to learn all those rules and keep up with them. They change.
Yeah.
They change.
I can add that if you think you're going to be doing a lot of rules-related research, or if you run into problems, Professor Pavia is our expert on that. I still ask advice from him on it. Yeah, so he's very good at that.
Well, one last thank you to our panel. Thank you for your time. Your advice. We really appreciate your Saturday afternoon. But that's the end of our program today. If you're going, I hope you have a very nice time. There's response. Thank you for coming for a Saturday morning. And we will, I will circulate a link to our research guide, which have all the substantive things that we covered, and I'll circulate